Hello and welcome to the conversation on News Central TV. I am Rita Omodia. Now on the conversation we get to discuss trending political issues across the African continent. And today on the conversation, a sigh of relief in the camp of Nigeria's separatist leader Nnamdi Kanu, after Nigeria's appeal court put an end to his legal travails by dropping all the 15-count charges of terrorism brought against him by the federal government. But is it Uhuru yet? Well, after 14 months in detention, it remains to be seen whether the separatist leader can be called a free man. And away from Nigeria, we do know that both Russia and Ukraine have been vying for influence in Africa. And the efforts have come under test in a vote against the annexation of some Ukrainian territories by Russia that left African countries divided. We shall be looking at all these on the program today. Stay with us. Now we begin in Nigeria, where a three-member panel of the Court of Appeal in Nigeria, sitting in the country's capital, Abuja, has installed the leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, of the 15-count terrorism charges brought against him by the federal government. In the unanimous decision read by the lead judge, the appellate court faulted the process through which Kanu was taken before the Federal High Court in Abuja to answer to the charges, ruling that a lower court had no jurisdiction to try the case. While supporters of the embattled IPOB leader took to the streets in some parts of the southeast region to celebrate the verdict, the Attorney General of the Federation and Minister of Justice, Abubakar Malami, SAN, reacting to the judgment of the Court of Appeal, clarified that the detained IPOB leader was only discharged and not acquitted by the court and will seek all available legal means. Kanu, leader of the group agitating for the actualization of Biafra as a sovereign nation, was rearrested in Kenya and brought back to Nigeria on June 28, 2021 to continue his trial bordering on treasonable felony. Since the alleged unlawful repatriation to the country, the IPOB leader, who was accused of making utterances capable of threatening the corporate existence of the country while in the United Kingdom, has been in the custody of the Nigerian Secret Police amid several court cases. And now joining us for this conversation, we have Barrister Ifeanyi Ejiofor as a counsel to Nnamdi Kanu. We also have Emmanuel Onwubiko, the National Coordinator, Human Rights Writers Association of Nigeria, Huriwa, join us from Abuja. Gentlemen, welcome to the conversation.
Thank you very much. Thank you so much for having me on your platform.
Thank you. So now I'll begin with... Yes, we can hear you. All right, so I'll begin with you, Barrister Ifeanyi. Now, looking at the ruling, the appellate court said the federal government did not comply with the procedures for the extradition of the IPOB leader from Kenya last year. According to the African Union and International Convention on Terrorism, what exactly are the conditions for extradition violated by the Nigerian government, which a state must meet?
Thank you so much. We are talking about relevant laws, protocols, and conventions to which Nigeria is a state party, and also laws which Nigeria ratified and it becomes part of our laws. First of all, we're talking about OAU conventions, charter and protocol, ratified by Nigeria.
Barrister Ejiofor, can you hear me? Okay, all right. While we still wait to get Barrister Ejiofor's audio, we'd like to hear from Emmanuel. Now, Emmanuel, in a case of extraordinary rendition, some rights experts, you are also part of the Association of Human Rights Experts. Now, they have termed it as an abduction sanctioned by President Muhammadu Buhari. Now, will there be penalties for this supposed contravention of human rights, and how grave exactly is this?
Yes. I think the panelists of the Court of Appeal were actually, they made a very sound judgment, very sound decision, because first and foremost, you cannot build on a faulty foundation. If you want to charge a citizen or an accused person for an offense, you have to state clearly where the offense was committed. And in the case of Nnamdi Kanu, he was simply abducted by the security forces and brought back to Nigeria. And I think the appeal court is saying there are protocols, there are established conventions, established order that Nigeria should follow if you want to arrest somebody that you believe has not showed up for his trial, and you have to really say from where have you arrested him from? How did you arrest him? How did you bring him back? This is very, very important. These are very important questions, because you can't just pick somebody up from somewhere without any definitive, condition precedents met. You just pick somebody up and you didn't observe the human rights, provisions that Nigeria is a necessary signatory to the African chapter on human and people's rights, and the Universal Declarations of Human Rights, and a lot of other international human rights, treaties and covenants that Nigeria is a signatory to as a member of the United Nations. You don't just act out of nothing as if the country is a banana republic. Nigeria is not a banana republic. Nigeria is a country that is governed by law.
Okay, thank you so much, Emmanuel. Now, still on this violation of human rights of which the appellate court has ruled on, we have joining us again Barrister Ejiofor, who is the counsel to Nnamdi Kanu, and we're still on that particular issue. So on what grounds, what exactly were the laws that the Nigerian government violated?
I was on the verge of listing the laws violated by the Nigerian government before the network interrupted. We are talking about Section 15 of the Establishment Act, Cap 25/204, which stipulates procedure through which a citizen who is of fugitive who is expected Nigeria to face trial, to procedure to be adopted before the person can be formally brought into the country to face trial. Then we also have Article 12 of African Charter on Human and People's Rights. These are laws Nigeria ratified and they are part of our laws today. We also have mutual assistance in criminal matters within the Commonwealth Enactment and Enforcement Act, M24, Laws of the Convention 204. This law, under Section 4 to 6, provide the procedure to be followed by the federal government in extraditing a person who they are bringing into test trial, then which require the consent of the state of refuge of the person before the person can be extradited. In this case, we also have Article 1312 of the Universal Declaration of Human Rights, 1948, which also provides for the right of freedom of movement by the person. We also have African Charter, also the Convention on the Prevention and Combating of Terrorism, which provided for the stringent conditions to be adhered to in the establishment of the citizen by Nigeria State. These laws were grossly violated by Nigerian government. And in the language of the court described the actions of the federal government as effective lawlessness. And the court also observed rightly that the court ought to have, first of all, determined the manner in which the person brought the court and court to face trial was arrested or abducted. Because the fact of the abduction in Kenya and extraordinary rendition without being subjected to extradition proceedings is all things before the court. He was abducted on 19 June 2021, subjected to torture, detained at a facility which stopped a conventional security facility, and for almost 8 good days before he was forcibly returned to Nigeria. Now, The law is very clear. You cannot violate this law and expect trial to go on. The court said no. Thank God that the federal government having violated this law, that the court now decision to even intervene the trial in the first place. That what the court should do is have inquired how what is taught. So, and in the application of that before the court, including the evidence of facts and evidence before the court, the federal government never disputed the fact that Mazi Nnamdi Kanu, our client, was appointed in Kenya as time and year stated. Or the fact that he was forcibly returned to Nigeria. These facts were never disputed by the federal government. They were all admitted. Even in appeal, our brief of argument passed before the court of appeal, and specifically comprehensive addressed this issue of extraordinary rendition was not responded to by the federal government. And court said no, that the federal government ought to have, in the first place, the court ought to have decided one or the other which declined the Mazi Nnamdi Kanu was brought before the court.
All right.
So having violated this extant international laws and protocol and conventions to which Nigeria State is a first party, that no court in Nigeria will have jurisdiction to entertain any charge arising from an offense allegedly committed before it was hunted for, or offense allegedly committed when it was extradited to Nigeria.
Okay, Barrister Ejiofor, now on that last ruling which you gave now, which the appellate court, that no court has the necessary jurisdiction to entertain this suit because they have to first of all answer how he was gotten away from Kenya due to the violation of extradition processes and also violation of human rights. Now, does this mean that this ruling by the appeal court is not answerable to Supreme Court? Does it mean the Supreme Court has no say in this matter?
No, the point I want to stress here, which is very stark, by the decision of Supreme Court in the case of Olusegun against FRN, that decision was just the Supreme Court decision. The federal government has right to appeal against the judgment of the court. That's the option available to them. But there was a declaration by the Court of Appeal yesterday, and not by the Court of Appeal, that Nnamdi Kanu, having been discharged, should be released forthwith. Now, that order cannot wait until they completely exhaust the right of appeal for the Supreme Court. They must first of all obey that order of court, of appellate court, before exercise the right to appeal. So what it means now is that the compliance with directive, the correction order by the court for you to be released must be automatic. And since in the case of FRN against FRN, there is no state that can be granted in the current order of succession. So the federal government has the option available to them now. Having been back from being trial before any court in Nigeria, because they have the only option to obey the order made by the Court of Appeal in this regard by complying and releasing him without further ado. And interestingly, they were caught when this order was made, and they have no option to obey the order of court. Of course, of late their way that recent government Court of Appeal just few days ago, when the academic staff was for university appealed against another structure, another directing them to resume academic activities before hearing the main appeal.
Okay.
Academic staff, let me finish. Academic staff of the university brought to Court of Appeal to get that order stayed. And Court of Appeal said no. Go and obey the order of the underside court first. Obey the order before complaint. So the federal government has no option in the present case than to obey the order made by the Court of Appeal before going to Supreme Court. The Supreme Court will not entertain a situation whereby you will be in presence of court order before approaching him for any remedy. Thank you.
Okay, thank you, Barrister Ejiofor. You've actually laid the cards right there on the table that before any appeal, you first of all have to answer how Nnamdi Kanu was actually gotten away from Kenya. Those questions have been put in place by the appellate court. Now, I'm sure you've gotten the news from the Minister of Federation, that is Abubakar Malami, which said that he has not been discharged. He has been discharged but not acquitted. Now, he has been in the custody of the DSS, and you said that the federal government does not have any option but to answer to the appeal court and free him. But the DSS has not said anything about it. So what's going to happen next? What if the federal government or the DSS still keeps Nnamdi Kanu in custody?
DSS have no option. They have no option. They are just made there for detention. that to comply and obey the order made by the Constitutional Court of Record. Now, let me correct an impression. Now, I have addressed the leadership made by the learned appointed on the Convention, and obviously, I faulted the position in law in my legal argument. And the point is very clear. The point is very clear and must re-emphasize that the Court of Appeal, the decision of the Court of Appeal yesterday, being 13th of October 2022, the court said that by virtue of the manner in which Mazi Nnamdi Kanu was abducted in Kenya and extraordinary admission to Nigeria, let me say this clear to you. The Court of Appeal agreed with us that Nnamdi Kanu was abducted in Kenya. Now, the court said no, that action, that violation, or brought as a back to further proceedings. And court proceedings now, court proceedings to also talk out the remaining 7 count charge. So, in the hands of the law, there is no other charge pending before any court against Nnamdi Kanu, or pending before a federal court against Nnamdi Kanu.
Okay.
The court also proceeded to strike out that remaining 8 count charge. So, the federal government cannot resuscitate that charge again. The charge is struck out by the Court of Appeal. So, there's no charge pending against him before the Court of Appeal. On the decision of the Court of Appeal yesterday, the federal government cannot effectively commence any other charge. If the person the one that was struck out, commence any other criminal proceedings or indictment against Nnamdi Kanu, because that has been led today. The decision of the Court of Appeal yesterday operates as a total bar for anything of prosecution arising from the charge as struck out or any other charge.
All right.
So, no charge can be maintained against Nnamdi Kanu today in any court in Nigeria. What they will do is to comply with the court order and kindly allow him to go. You cannot.
All right, Barrister Ejiofor, I'll have to stop you there. I think you've laid your emphasis now, which they have to first of all comply with the order of the appellate court. I'll just hold on that thought. I'll bring you in shortly, Barrister Ejiofor. But I'd like to bring in Emmanuel at this point in time now. Now, Emmanuel, Nnamdi Kanu has been on the news. He's the leader of the separatist group IPOB, which has been proscribed by the federal government. Now, how popular is Nnamdi Kanu and his separatist propaganda in the eastern region?
You mean how popular is he?
Yes, because we have some Igbo saying they're not going along with the separatist propaganda. So how popular is Nnamdi Kanu in the eastern region, especially the separatist propaganda? Because with his release, there have been talks about IPOB going after their normal plans.
Well, I think the group that is known as IPOB has systematically gained some kind of traction and some kind of attention from a lot of young Southeasterners because of the fact that there is this perception that the government of the day has not actually guaranteed the respect to the fundamental rights of all citizens has been equal before the law, that a certain class of persons or certain persons from some sections of the country are to be treated as first-class citizens while the rest of the country are treated as second-class citizens. So a lot of people are really questioning what is the sense of staying together in one country when you will have, for instance, there is a law that is passed by some states prohibiting open grazing by cows. And you have the federal government telling the state government, we don't want you to enforce such a law. We want you to allow, cows to just move around wherever they want to move around. And if they don't want to stay in the forest, they can stay in the forest. You know, a lot of things that have been done by the government to portray a certain class of, persons in the country as if they are much more important than the rest of the society. So Nigerians, especially from the southeastern part of the country, feel that they are disconnected from the political life, the economic life of the country. And so when this IPOB and the rest of them came up with those ideas that they want to call for self-determination, they were able to gain a lot of membership from the younger population. You understand? So I think Nnamdi Kanu is not somebody you just write off in the Southeast. He's a very he has this messianic kind of followership among younger people. So many young people in that part of the country.
Okay, now looking at this mosaic figure that Nnamdi Kanu, that you say Nnamdi Kanu has in the southeastern region, due to the fact that some people feel discriminated over by the federal government. Now, 2023 is around the corner, and there are talks that probably that discussions will leave the situation of Igbos leaving the 2023 election and rather going towards the 2023 propaganda of leaving the country. So how exactly is the release of Nnamdi Kanu, what effect will it have on the 2023 elections?
Well, I think first and foremost, Nigerians are spinning a whole lot of conspiracy theories around a verdict that was issued by the Court of Appeal. Secondly, I think the Minister of Justice and the Attorney General of the Federation is actually not presenting himself as the Attorney General of all of the Federation. He feels like he's an Attorney General of a certain class of people, maybe the Arewa people. If a court says this man has been discharged from all the charges that you have filed against him, and you're saying they are going to explore the possibility of an appeal, why don't you want to respect the Court of Appeal's decision first before you talk of appealing against the decision of that court? Is it not the same government that told ASU, you have to respect the National Industrial Court before you talk of appealing? So now the government is trying to say they want to explore. You want to explore what? They should respect the court first and foremost. That if the government intends to file appeal, that is their own business. The release of Nnamdi Kanu has no negative effect on the election that is coming up.
Okay, does he have a positive effect on Peter Obi's candidacy? Because we have Peter Obi from Anambra State, the former governor of Anambra State, vying for this presidential position. Does it actually give him a plus in this election?
If I get the question you are asking, you are saying if...
Yeah, you were talking about the fact that there is no negative effect of the release of Nnamdi Kanu, especially with regards to the separatist propaganda. Now, I'm asking that we have former Anambra State Governor Peter Obi, who is vying to succeed President Muhammadu Buhari in the 2023 elections. So are we likely to see more votes from the Southeast for Peter Obi?
Well, Nnamdi Kanu and his group are actually not, they're non-partisan. They're not actually talking about the election that is coming up next year. I think what they're concerned about is to try to convince Nigeria as a federation to grant them the right to a referendum, a vote, to say whether they want to remain as part of the country. That is their agenda basically. But the release of Nnamdi Kanu is going to have a lot of positive implications for the security of the Southeast, because a lot of younger people have this perception that his detention is unconstitutional. His detention without a possibility of being prosecuted within a limited period of time is unconstitutional. You don't keep a citizen of a country, or even a citizen of Britain. If he's not a citizen of Nigeria, he's a British citizen. There are stipulated period within which any case you're going to file against that citizen has to be heard and determined. And the right of the person being granted bail is within the discretion of the judges. So when you now continue to detain a person and he spends almost 2 years, 3 years in detention, you don't grant him bail, you don't even recognize that as an accused person, he is he's innocent until a contrary decision is reached by the competent court of law. There are a lot of issues that borders on fairness, that his trial has not followed those legal those steps, and that he is being denied of his fundamental human right. I think his release, rather than have a negative effect on the election that is coming up, it's going to have a very positive effect, because it will stabilize the Southeast in terms of insecurity. In terms of insecurity, it's going to go down And I don't think Nnamdi Kanu will just come out of the detention and jump into politics or jump into maybe try to kind of create crisis for anybody. He's not going to create crisis for anybody. He has the right to his freedom.
Okay, all right. So I'd like to bring in Barisay Ejiofor his counsel to Nnamdi Kanu. Now, earlier on, there were talks about the health status of Nnamdi Kanu, and right now, the appellate court has called for this release, the charge of Nnamdi Kanu. What are the next legal options for Nnamdi Kanu at this point in time?
Ordinary supposed to have been handed over to us today, and we're having delayed to that at the time again. So, but give and take, have it first time on Monday morning. And when we have that judgment can be on Monday morning, we will start it on the SSS. And also, so before our SSS, we also start on the appointment of the Federation. But today, it was, Federal government was also represented in court yesterday by the Chief State Council, and it was in court when the judgment was delivered. So the judgment of the court took immediate effect upon being delivered yesterday. So in the eyes of the Nigerian law, Nnamdi Kanu from yesterday became totally legal without force of law, without any backing of the law. So we are waiting for judgment. Hopefully by starting on the day, we personally start training on the directors of the SSS, and also start on the great Chief Federation. Then we now have to company staff. We ask them that to have a client because that is what we need their client to us. So there's no two ways about it. And the order of the court made on 13th day of October 2022 to the fact that Nnamdi Kanu should be released immediately must be obeyed to the letter.
Okay, all right.
The government have no chance to say no to the dictator of other court. And also, don't forget that on 10th of June 2022, the United Nations Working Group on Arbitrary Detention issued a communication wherein they directed the federal government to release Nnamdi Kanu unconditionally and also account for the corruption on account of the gross violation of his fundamental rights. And also, thankfully, yesterday, is not just for the court of appeal. Also, how that Nnamdi right was grossly violated by the action of the federal government.
Okay.
The doctor and the extraordinary yesterday. So it was the position of the court of appeal yesterday that the judge was also violated justly and it very justly. So now they have no option than to make the court. So the president of the court delivered yesterday. And now that's one of the court. And I've mentioned before now that by decision of the authority of the Supreme Court, decision on the comment against Federal Republic of Nigeria, we say that no form of stay can be granted when other court is met. So there's no court to not allow them to be in contempt of the court by pushing them. They must obey the declaration of the court, and they cannot go to Supreme Court to challenge the judgment of the court.
Okay, Barisay Ejiofor, I'll have to let you go at this point. Sorry for that, Barisay Ejiofor, but I think your point has been made there. There's been ruling by the appellate court, which has ordered the discharge of the separatist leader Nnamdi Kanu. We're still waiting from your response. You're still waiting for the release of Nnamdi Kanu, who is still in DSS custody. And the Attorney General of the Federation has said that the federal government will still apply other options as he has been discharged but not acquitted. Thank you so much, Barisay Ejiofor, counsel to Nnamdi Kanu, and of course, Emmanuel Onwubiko, the National Coordinator, Human Rights Writers Association of Nigeria, for joining us on the conversation.